welcome everyone to our Cover Talk webinar today, where Charlie and I are going to talk to you about the business interruption insurance and the Supreme Court's decision in the FCA test case, which I'm sure everyone will be well aware of. My name is Ben Hardiman. I'm a partner in the Manchester office of our insurance disputes practice. Charlie is an associate in our London office. And just to start off with a couple of points of housekeeping. Firstly, the session is being recorded. The recording will be available afterwards via our website and our YouTube channel. Something I never thought I would associate with Mills Reeve, but there you go. Secondly, there will be some time for questions at the end, so please do post those in the chat box as we go along. At the end, Harriet Strevens, our invaluable PSL, is going to host those questions, and Charlie and I will endeavour to answer as many as we can in the time available. And finally, in a little piece of innovation for us, we do have live caption available today, which is providing a live transcript if that was required for you. So to our agenda today, and since I'm a solicitor, I need to give you a caveat. We've got 15 to 20 minutes today, which is intended to review what is arguably one of the most important decisions to impact on the insurance market and potentially the UK economy in recent memory. The judgment itself is something like 116 pages, and there's been a fair amount of follow-up via the FCA in the 3 weeks since it's been handed down. So we don't have time to give you a chapter and verse analysis today, but anyone who's attended one of our Cover Talk sessions previously will know that they are intended to be relatively brief and to the point, and they're supposed to give you some key takeaway thoughts on the subject in question. So with my suitable caveat in mind, what I'm going to do is to review the Supreme Court's analysis of the wording of the clauses and the relevant policy triggers. Charlie is going to cover the causation aspects of the decision and the all-important Orient Express case. I'll then provide some concluding thoughts, which ought to then leave some time for questions. Now, Charlie and I spoke beforehand and tried to work out how we might show you a picture of the judgment in one slide. And here it is, good or bad. It is our attempt to show you something which we would like you to keep in mind as we go through the talk, because we think it helps demonstrate the issues that we're going to discuss and that the Supreme Court has touched on. And these issues run through the entirety of the judgment. So for every policyholder who holds a policy affected by the judgment, they'll have a policyholder, the policyholder will have a business address. There will be a relevant vicinity or radius, which is shown by the black circle on the screen. And then there will be cases of COVID, and they are represented by the purple dots. Some will be within that radius, some will be outside. And this pictorial representation runs through both how the clauses need to be interpreted, particularly the disease clauses, but also how the causation issues play out. And we will come back to that in a moment. So firstly, to the wordings, and there's three wordings under consideration. They're all within the scope of the non-damage extensions. I'm sure all of you will have heard of them, but the first is the disease clauses. And they essentially provide insurance cover for business interruption loss caused by the occurrence of a notifiable disease within the specified radius of the policyholder's business. The most common radius are 1 mile or 25 miles, generally speaking. Now, the High Court had found against the insurers and they'd appealed. The FCA also brought an appeal in respect to the High Court's decision on the QBE wordings. Now, the Supreme Court took a different and more restrictive view than the High Court. And as starting to read through the judgment in order, it looked like it may be a bad news position for policyholders. But as we'll come on to explain, that is not the case. But importantly, and unlike the High Court, the Supreme Court didn't look to reach different decisions on different wordings. What it's done is to give a decision which affects all of the disease wordings alike. And what it's decided is that the plain language of the disease clause, i.e., generally speaking, any occurrence of a notifiable disease within the radius, means exactly what it says. Cover is triggered by an occurrence within that radius. In some ways, that seems fairly obvious, but what does it mean in practice? Well, as you'll see, the words notifiable disease are capitalized, which means it was defined. And that definition is the illness sustained by any person resulting from a human infectious or contagious disease. And so what the Supreme Court said is that from the perspective of cover, what we should be focusing on is the illness sustained by an individual at a particular time and a particular place. In many ways, we need to forget about words like pandemic, disease, outbreak, and instead focus on the person who has suffered the illness. And I think if you look at it that way, that makes it easier to understand why the Supreme Court found that these clauses provide cover for a case of illness within the area, but they provide no cover for a case outside of it. Now, cases of illness outside of the radius, so thinking back to the previous slide, remain relevant. And this is where I risk veering into and stepping on to Charlie's toes in relation to causation. But what the Supreme Court found is that the wording of the disease clauses made no attempt to restrict cover only to cases occurring in the vicinity as opposed to those outside. And that is really quite important in circumstances where the very nature of a pandemic means that disease quickly and rapidly spreads far and wide. And so without words or exclusions to the contrary, the existence of cases outside the vicinity or the radius is not a basis to restrict cover. And Charlie will talk further about that in a moment from a causation perspective. And so to the second part of this table on the screen, under prevention or denial of access wordings and the hybrid clauses, I've grouped them together because of the way they've been treated. But a prevention of access clause provides BI cover where the losses result from the decision of government, police, local authority to impose restrictions which prevent access to or use of the premises. And as I say, the hybrid clause is a combination of the disease and the prevention of access wordings. Now, the High Court's decision on this was fairly restrictive. And its decision largely fell in insurers' favour, but the Supreme Court has overturned it, and it's done so for two key reasons, and both fall heavily in favour of policyholders. So firstly, the nature of the intervention necessary to trigger the cause. The High Court, the Supreme Court said, was wrong to decide that it was only an instruction or a restriction which has full force of law, which is sufficient. An instruction will be sufficient to amount to a restriction if compliance is expected or required. It doesn't necessarily need force of law behind it. So when the Prime Minister instructed businesses such as bars and restaurants to close on the 20th of March, it may not have been legally enforceable at that point. We all clearly knew what was meant by it. And so that amounted to a restriction. Secondly, the nature of the closure. And again, the High Court was restrictive on this. A complete closure is necessary. The Supreme Court has rode away from that. The requirement for there to be a denial of access or a prevention of access can be satisfied if a business is unable to use a discrete part, either of the premises or of its business activities. And so the court gave an example of a golf club with a bar. The course was allowed to stay open, but the bar was not. So there's been an inability to use that particular part of the business and the premises. Now, it might be discrete, but it's still important for the purposes of the business generating revenue. Overall, therefore, the Supreme Court's decision was more generous to policyholders than the High Court was. It makes it easier for policyholders to trigger cover. And in some areas, it's going to give policyholders the chance to benefit from cover, even where they manage to keep parts of their business open. So with the clauses in mind, I'm going to hand over to Charlie now to discuss causation.
Brilliant. Thank you, Ben, and good morning, everybody. So once you've identified the insured peril, which will either be disease, denial of access, or a hybrid of the two, the next step is to look at how that peril has caused loss. Now, as a sort of brief reminder, I've put the key elements of an insuring clause on the slide, and it's that second step in the sort of pinky purple text that's known as the causal link or causation, and it's that connects the peril to the loss. Now, this is a really important part of the test case, and it's what turned a partial victory for insurers into a total defeat. Now, causation isn't always contentious. So take, for example, a property policy which covers flooding. Now, if the property is flooded and the carpets are ruined, then clearly that damage was caused by the flood, and so the policy will respond. But it gets a bit more complicated when there's more than one cause of loss. So to take that example a step further, what if the policy provided for flooding but not fire? And what if a flood caused the electrics to explode and then the property burnt to a crisp? Would the cause of loss be the flood, or would it be the fire? And to answer this question, the court will apply two tests. The first of those tests is known as the proximate cause test. And rather unhelpfully, every time the courts try to define what they mean by proximate cause, they just seem to give it a new name. But the idea, which has been developed over the last 100 years of case law, is to take a common sense approach to determine what, as a question of fact, caused the loss. So it will be dealt with on a case-by-case basis. Now, an example is probably the best way to explain this. So let's have a look at the case of Leyland Shipping and Norwich Union, which is a case from way back in 1918. Now, funnily enough, I did a little bit of research and I was trying to find some sort of TikTok videos or Instagram stories, but apparently that technology hadn't been invented in 1918. So I've had to paint a bit of a picture with a photo of myself on a sinking dinghy, and hopefully that's helpful. Now, in this case, the insured ship was hit by a torpedo, which caused it to take on water. The ship was then hit by a cyclone, which accelerated the sinking, and eventually the ship was lost. The court held that the torpedo was the proximate cause of the sinking, and the cyclone simply accelerated the inevitable. And this leads nicely on to the next test, which is known as the but-for test, which is probably the most familiar of the causation tests. And it asks the hypothetical question of what would have happened but for the insured event. In other words, what would have happened to the ship if it hadn't been hit by the torpedo? Would the cyclone have caused it to sink anyway? And if the answer to that question is yes, then whilst the torpedo might have been the proximate cause, the ship would have sunk in any event, and so causation is not proven. Now, in the Leyland Shipping case, the court held that the answer was no, and so the torpedo was held to have caused the loss. So now you're probably all thinking, well, that's great, Charlie, but what on earth has this got to do with COVID? Well, as discussed by Ben, in the test case, insurers argued that where an insuring clause has a defined area, which is usually a 25-mile radius from the premises, there are effectively two occurrences of COVID. The first is the occurrence of COVID within the radius, which will be insured, and the second is the occurrence of COVID outside of the radius, which won't be insured. Insurers said that the occurrence of COVID outside the radius was the proximate cause of loss. Now, theoretically, this does make sense, as the occurrence outside the radius is likely to have been far greater than the occurrence within. And insurers also said that but for the occurrence of COVID within the radius, there still would have been a national lockdown in response to the occurrence outside the radius. And again, this does seem plausible. But the Supreme Court rejected these arguments and said that a more common sense approach is required, where there are a series of events, each of which cause the insured peril, but where none of them on their own are sufficient to cause the loss. Now, the Supreme Court gave quite a neat example, or at least I thought it was quite neat, of 20 people pushing a bus off a cliff, but where it only actually needed 13 of them to push it. Now, each individual could quite correctly say, well, you can't blame me. If I hadn't have been there, the other 19 would have pushed it off the cliff anyway. And whilst each individual would technically be correct to say that, I think we would all agree that that's quite an unreasonable argument. And ultimately, it would lead to all 20 people being not responsible for the bus falling off the cliff. And the court said that in this sort of situation, each of the 20 people would be a separate but equally effective cause of the loss. Now, applying this logic to COVID, the Supreme Court said that each individual occurrence of COVID was a separate but equally effective cause of the national lockdown. And so it doesn't matter that the occurrence within the radius is significantly smaller than the occurrence outside of the radius. Each individual occurrence had the same effect. Now, insurers then heavily relied on the case of Orient Express hotels, which has been getting a lot of coverage recently. In this case, the insured hotel was badly damaged by Hurricanes Katrina and Rita and the flooding that hit New Orleans shortly after. In this case, the court applied the but-for causation test and held that in the hypothetical world where, albeit by some miracle, the hotel had not been damaged, customers wouldn't have visited anyway because the wider city was so badly affected by the hurricanes. Interestingly, or at least I think it's interesting, this case was heard by the then Mr. George Leggett QC in the initial arbitration and Mr. Justice Hamblin at the High Court. And these two have since been promoted to the Supreme Court, which is perhaps why you might recognise their names. And they were on the panel that heard this test case. So the question on everyone's lips was, would they depart from their own earlier judgment? And in short, yes, they did. Orient Express was overturned. And in the words of the judges in question, we gracefully and good-naturedly surrender former views to a better considered position, which is a very eloquent way of saying we were wrong. And once the Supreme Court was satisfied that the causation tests were met, they then needed to turn to the calculation of loss and what factors should be taken into account and what should be disregarded when calculating this. Trends clauses are used in business interruption policies to help calculate or adjust losses suffered, and they're designed to exclude losses that would have been incurred regardless of the insured peril. Now, another example is probably quite helpful here. So consider a pub that is forced to close because of a fire in March, but in a further blow to the pub, the government abolished the sale of alcohol in April. Now, in these, thankfully, hypothetical circumstances, it is highly likely that the pub would have been forced to close in any event. And so the pub will only be covered for losses suffered between March and April, being the month before abolition. Applying this logic to the test case, insurers argued that regardless of the lockdown, customers wouldn't have attended anyway because of the high risk of catching COVID. Now, if you're feeling a really strong sense of deja vu here, or you think that Ben and I are just repeating ourselves, then you're absolutely right. This is almost exactly the same as the causation argument, but it's being applied to the calculation of loss. And probably unsurprisingly to most of you, given the ruling on causation, this argument was rejected, and the court held that you cannot use trends clauses to restrict the scope of cover otherwise provided for in the policy. And in a further blow to insurers, the Supreme Court also decided that pre-trigger losses would also be covered. And so therefore the policies would cover losses incurred either before COVID was made a notifiable disease in the case of disease wordings, and before the national lockdown for denial of access and hybrid wordings. So despite insurers getting a slight victory on the definition of the insured peril, their arguments on causation and loss were completely rejected by the Supreme Court. Now, I appreciate this has been a real whistle-stop tour of a topic that you could probably spend years studying, but I will now pass you back to Ben to discuss what this all means going forward.
Thanks, Charlie. So just a very quick roundup with the most boring slide we could come up with here. What's the impact of the decision? How far-reaching will it be? Well, these clauses generally fall within policies aimed at SME businesses. Just on stats alone, that's of interest because the FCA has estimated that 370,000 policyholders are likely to be affected by the decision. Now, bearing in mind there are something like 6 million SME businesses in the UK, we're only actually talking about 6% of those businesses who are likely to benefit from the decision. And that is some way away from what some of the newspaper headlines were suggesting on the day of the decision. And I know for many brokers on the call, I've spoken with many in the 3 weeks since it handed down, have come under real pressure from their clients in terms of policyholders coming to them and asking why they no longer have cover. Now, I'm not in any way seeking to downplay the decision. And as Charlie says, I think it raises real questions that actually do go beyond the scope of BI cover. It's a remarkable feat that the insurers and their regulator have worked together to get to a decision from the highest court in England and Wales in a hugely complex area in the middle of a pandemic and without stepping foot in court in 6, 7, 8 months' time. But the reality is the majority of BI policies either only respond where there's physical loss or damage, or if there is an extension, cover is generally restricted to a defined set of named diseases, and COVID won't be one because it wasn't known about when the policy was written. Those policies remain unaffected by this decision. Now, some of you will have heard me speak in November following the High Court's decision, and at that time I predicted that I thought there would be still a level of uncertainty whatever that the Supreme Court decided. My view on that hasn't changed. This is a complex judgment. It's said to affect potentially 700 policies, and there are inevitably going to be differences in how those policies are interpreted in light of this decision. We also have no guidance on how to quantify loss. So, for example, partial denial of access is a win for policyholders, but how are insurers and adjusters going to work out what loss is suffered as a result of one part of the business closing while another one stays open? I'm not sure how easy it is to divide the two. What we do know is that the FCA is not going to rest. It's not going to sit on its laurels. It's already encouraged insurers effectively to do the right thing via its recent Dear CEO letter. It said that the decision gives clarity and certainty, and it says that claims should now be paid in full as soon as possible. Now, whether there will be more litigation is a question that's come up a number of times. We may well be asked that question during the Q&A, but I think one thing that comes out of the Dear CEO letter and what may cause insurers to pause is that the FCA has suggested that if insurers do decide that litigation is necessary, they're expected to agree to pay the policyholder's costs and not to seek their own costs from a policyholder. So that'll be an interesting dynamic going forward. Now, that's all that Charlie and I have to say. We've just about got within the 20 minutes, so that leaves 10 minutes for questions. So I'm going to hand the baton back to Harriet to take that up.
Thank you very much indeed, Ben. Interesting point about paying for policyholders. Aggregation, a knotty issue, I know, for everybody, but one question, how do you think this decision is going to affect questions of aggregation? For example, do you think that there will be further litigation about the number of occurrences of disease or closure of premises?
I'm happy to take that one. I think the important point here is that aggregation was specifically excluded as a factor. So it wasn't something that the FCA or the Supreme Court was required to look at. What the FCA did say in guidance previously is that questions of number of occurrences and the like is something that insurers will just have to deal with as part of the normal claims handling process. So that goes back to what I said a moment ago. Will there be more litigation? Perhaps yes. I think the answer is it's very difficult to give an answer. We don't have necessarily all of the wordings. There's potentially 700 that could respond. On a really high level basis, what we do know is that the interpretation of a word like disease, for example, suggests that there could be thousands of policy triggers if each individual illness is an occurrence. But I think, as Charlie said, the way that causation and particularly pre-trigger losses have been addressed is broad enough that perhaps insurers, certainly I suspect, will argue that it's COVID itself as opposed to those individual instances of illness that are going to be the event to consider. So, but again, yeah, I suspect this might be an area that insurers will look at.
So we're very much down to policy wording, aren't we?
I think we are, Harriet, yes. I mean, you only have to think about a restaurant with 5 different premises, for example. How do you treat that? Yeah. So lots of issues in that area.
Can I turn to exclusion clauses? Charlie, question for you, if I may. What impact do you believe this will have on the operation of exclusion clauses?
Yeah, good question. And actually, this is something that we've already been asked by insurers to advise on in the last week or so. And there it was in the context of a cladding exclusion. So the general rule is that where there are two causes of loss and one of them is excluded, then generally the exclusion will prevail and the entire loss will not be covered. And whilst the Supreme Court didn't really look in much detail at exclusion clauses because it wasn't really relevant for the wordings they were looking at, they did mention it briefly, and they don't change the position. So the rule that comes from a case called Wayne Tank remains the rule, and we remain reasonably confident that they're unaffected. And it probably is quite a good way for insurers to sharpen up their wordings. Although that's wonderful in hindsight. Obviously, you couldn't exclude COVID-19 before you knew it existed.
Fine. Thank you, Charlie. A last time question, Ben, as time is running out on us. What does a policyholder on a disease wording have to do to prove that there has been a case of illness in the radius of the premises? Can you throw some light on that?
Yeah, well, actually, so the FCA has produced draft guidance. It did it before Christmas. It's on the FCA's website, which is certainly something which people ought to look to if you're interested. There's been a number of things posted on that website, and we'll be including a link to that in the follow-up. But the guidance that was provided before Christmas, which has gone out to consultation, dealt with the question of proof. The consultation has now closed, so we're waiting for the final view. But in short, policyholders are going to have to look at evidence of cases, so specific if you can show there is a case in the vicinity. Beyond that, it will be looking at data from the NHS, local authorities, Office of National Statistics, I think it is included in that. But once again, the Dear CEO letter shows that the FCA is pushing insurers pretty hard on this. They've said that if a policyholder can provide evidence, insurers are expected to put something forward that is stronger if they want to counter it. And the other point to just bear in mind is that insurers and brokers are expected, according to the guidance, to publish details of cases which have been accepted, with the view to then help other policyholders prove their own claims. And I do wonder whether this is going to be something that ultimately falls away as an issue for the vast majority of cases.
Thank you, Ben. We have very many more questions, as you might imagine, but unfortunately we're running out of time. So on this occasion, I'll pass the baton back to you, Ben, to conclude, if I may.
Thanks, Harriet. What we will do is to try to respond to any outstanding questions separately by email. Thank you very much for joining us today.